May I please, Lordship?
Yes.
Lordship, I beg to mention item number 31.
It's okay.
Let's go.
Yes.
Lordship, conducting counsel for the appellant, Jambi Singh, sir. He is out of station. Kindly may fix after 3 weeks, Lordship. Consent has been taken from the other party.
You are Mr.
D. Tali.
Sorry. Some Mr. The conducting counsel is out of station, therefore pray for adjournment of the matter for 3 weeks. The prayer not being objected is allowed. List this matter after 3 weeks.
Obliged, Lordship.
May I please, my lord? My lord, I like to mention item number 9 and item number 10. Item number 9, I am for the petitioner. Matter may be kindly take up on Monday.
Monday.
For Monday or after 1 week, my lord.
You are for the petitioner.
Yes, my lord.
Have you informed the other side?
Yes, government is there. Item number 9.
Praying for Monday
Yes. Yes, sir.
on the prayer of Land Council for the petitioner. Let this matter be listed on Monday. Okay.
And item number 10, my lord, on behalf of N. Anju, that is for respondent number 1. The matter may be kindly fixed for 24th November.
Who is for the petitioner here?
Petitioner is for government.
my lord.
Okay.
I have no objection, my lord, but there's interim, my lord. Interim may be continued.
There is interim?
Yes.
Okay. Miss
O permits.
Land Council. For the respondent number
1.
appearing on behalf of
N. Anju.
Ms. N. Anju, Land Council for the respondent number
1.
1. Pray for listing this matter
For-
on Monday.
No, for 24th November.
Okay. Pray for listing this matter on 24th, to which the Land Council for the petitioner has no objection. Prayer allowed. Let this matter be listed on 24th. Stop. The interim order passed earlier shall continue till there. Okay.
Much of it.
May I please, Lordship, I beg to mention item 16.
Item
16.
16.
My lords, these I have checked the file. The AD card has not been written till yet, my lord. There is a respondent number 2. He is the complainant.
You're for?
I am for the petitioner, my lords. Lordship, may I kindly list this matter on the month of December around 9th or 10th?
Land Council for the petitioner, Mr.
D. Gogoi, my lords.
D. Gogoi. Is present. Stop. The notice upon the respondent number
2, my lords.
2 is still awaited. Let's pray for, let this matter be listed.
9th or 10th December.
Second week of December.
My
Okay.
lords, my lords, there's an interim, my lords.
The interim order passed earlier shall continue till the next date of listing. Okay.
Obliged.
May I, Lordship? Beg to mention item number 29, Your Lordship. On behalf of B. Pathak, he couldn't appear due to some personal difficulties today. This matter may be fixed on 17 November, Your Lordship.
Ms. Rimi,
B. Pathak.
Land Council submits that Mr. B. Pathak, Land Conducting Council, has some personal difficulties today. Therefore, prays for adjournment of the matter and to be fixed on 17/11.
Of bless
The
you.
prayer is allowed. Have you informed the other side?
Yes, I have informed the government side,
Okay.
Lordship.
Let's pray. Let this matter be listed on 17/11.
May I, Lordship?
Okay.
Lordship, I beg to mention item number 24 on behalf of leading counsel T. Johnny.
It's in order. Let us see what is for what this has been listed. We'll see. We'll grant adjournment. Wait for some time.
Yeah.
What?
Your Honor, on last hearing, TCR was not received.
So this time we'll see whether TCR we have received or not. Okay, wait for some time.
Okay, highly ordered.
My lord, I beg to mention item number 18, my lord.
Yes.
In this matter, my lord, I was supposed to file affidavit in reply, but due to the absence of the petitioner, I could not file. I need some more time, my lord, 2 weeks.
The respondent is present? No.
Yes, I have informed them.
Okay. Ms. Ndangan, Land Council for the petitioner, prays for how?
2 weeks,
So
lord.
further 2 weeks time to file affidavit in reply. The prayer not objected. Accordingly, the prayer is allowed. This matter after 2 weeks.
Lordship, there is also an interim order which
The
may be
interim
continued.
order passed earlier shall continue till the next date of listing. Okay,
Also, Lordship, I beg to mention item 7.
7.
Yes. In fact, the learned counsel for the respondent is also absent, and he has also, we have actually talked and decided that, I mean, to pray for Lordship to fix it on 4th of December.
I cannot change since you have decided.
Sorry, wrong word.
On the prayer of the learned counsel for the petitioner, let this matter be listed on
4th of December.
4th, 12. Okay,
There is an interim order, Lordship,
the
here.
interim order passed earlier shall continue till the next date of listing.
Oblige.
Okay, till then, okay.
My lord, I beg to mention item number 30, my lord, for adjournment. The senior counsel is out of station.
Okay, so Shuda, you for the respondent.
Yeah, no, yeah, private respondent, for
Private
victim.
respondent.
Okay. Mr. Mukbam Party, learned counsel submitted the conducting, his senior, Mr. Muk Patel, is out of the station, therefore pray for adjournment of the matter, to which Mr. Kodapa, learned
Yes,
counsel
Koda.
for the respondent, private respondent has no objection, and to which the learned counsel appearing on behalf of the respondent has no objection. Accordingly, the prayer is allowed. List this matter after
3 weeks.
Below-
3
Short date may be given.
date.
Short date.
Date. you
List
want
after
date?
weekly.
Uh,
It will be
After
done.
3 weeks.
After 3 weeks.
After 2 weeks.
My lord, there's interim also. Interim
What interim?
suspension of the impugn order, my lord. And impugn order and decree, my lord.
Decree? In
Yes, my lord,
criminal appeal?
That order has been, this is an appeal, my lord.
Criminal.
Yes, my lord.
This is criminal appeal. Mila.
Then what decree was there?
Also, my lord, sorry, my lord, judgment has been stayed, my lord.
Okay. Date, when?
Any short date may be given. Mila.
Okay.
List after week may, it will be good for.
Give date? Okay, after 3 weeks, if you cannot. Okay.
Great.
Much obliged.
My Lordship, I beg to mention item number 13, appearing on behalf of Titaba, Your Lordship. Lordship, here the conducting counsel is unable to appear due to some personal difficulties. As such, matter may be kindly adjourned, Your Lordship.
Whether you have taken, no,
I have already
step-
informed the opposite.
no, whether taken steps upon the respondent?
We have already taken this step.
Okay, they have appeared. There is no office note in this case. Okay. When do you want, you said?
After 3 weeks, Your Lordship.
You are appearing on behalf of?
Titaba.
Okay. Taba is out of station.
No, not out of station, but due to some personal difficulties.
Okay, Miss Handi,
Yes, Chair.
learned counsel submits that the conducting counsel, Mr. Teto Taba, has some personal difficulties today, therefore pray for adjournment. He has also obtained consent from the learned counsel of the other side. Accordingly, the prayer is allowed. List this matter after
3 weeks. Your
3 weeks. Okay.
Also, Your Lordship, item number 28. That may be also adjourned, Your Lordship. After 3 weeks.
Criminal appeal,
Yes, Your Lordship.
similar order. After 2 weeks.
Yes, Your Lordship.
Okay.
With your pleasure, Your Lordship. May I please, Your Lordship?
Yes.
I beg to mention item number 6. On behalf of Mr. S. Tapin, Your Lordship, he is the conducting counsel. Your Lordship, he have some personal difficulty this week, Your Lordship. Your Lordship, may kindly pause this matter next week.
Next week.
Next week.
Have you informed the other side?
Yes, Your Lordship.
The counsel for the petitioner has no objection. Okay, Miss P. Sangita, government advocate for the state respondent, with the consent of the land counsel for the petitioner, prays for listing this matter after a week. The prayer is allowed. List this matter after a week.
Okay.
May I, Your Lordship? Lordship, I beg to mention item number 19 on behalf of Senior Counsel C. Gonsalves. Your Lordship, due to personal difficulties, he is unable to attend the matter over VC today. and kindly press for the matter may be fixed on 2nd of December
Why this has been listed for today?
to file affidavit in reply.
Affidavit in reply. You are to file affidavit in reply,
Yes, Your Lordship.
not yet filed.
Not
Taking
yet.
some more time.
Yes.
Okay. You have missed
KRB.
planning council. Appearing, your name is not there.
No, Your Lordship. I'm
Appearing on behalf of Mr.
Senior Counsel C. Gonsalves.
C. Gonzalez. Praise for. Father, how much time?
Your Lordship, kindly matter may be fixed on 2nd of December.
Affidavit in reply, not yet filed. Okay. Some more time to file affidavit in reply. Stop. As prayed for. Okay. You have informed the other side.
Yes, Your Lordship.
Okay. With the, okay, she has also informed the learned counsel appearing on behalf of the respondent staff. Please pray for. List this matter on 2nd December.
2nd of December.
In the meantime, the petitioner may file their affidavit in reply. Okay.
Deeply obliged.
My Lordship. Lordship, I would like to mention item number 17, Lordship. Lordship, I supposed to file affidavit in reply, Lordship. For
This
respondent.
is in order. Wait for some time.
Yes,
We'll
Lordship.
grant adjournment. But then
Lordship,
wait.
here is the.
We'll have to see the record.
Yes, Lordship. And Lordship, my friend supposed to take the step upon also some of the private respondents. Service is not completed. So, Lordship, if my learned friends agree, he is to take the fresh step against the respondents whose service is not completed, Lordship. If
Item
item 17, Lordship.
17.
Lordship, I will wait, Lordship.
This is in order.
Yes, Lordship.
We have
Order,
to see
Lordship.
the see the records. Then only order
Yes,
can be passed.
Yes, Lordship.
Otherwise, can wait for some
Yes,
time.
yes,
You have
Lordship. Yes, Lordship. I will wait.
urgent work.
Not urgent work, Lordship.
Then wait for some time.
Lordship.
Okay.
Your Lordship, I would like to mention item number 11 for adjournment. As the conducting council is out of station. Item
You are
number
for the
11.
petitioner. Who is for the other side? Have you informed?
Yes, sir. We have taken the consent, sir.
Okay. Mr.
Sonar.
No, you are Mr.
Gautam Nathung, sir.
Your name is there?
No, sir.
Learned council submits that. Sonar is not there.
No, dear, sir. Out of station, sir.
Okay, submits that.
Sir,
The conducting council, Mr. Sonar, is out of station. Therefore, pray for adjournment of the matter. For how much time?
sir, for 2 weeks, sir.
For 2 weeks. He has also informed the learned council of the other side staff. In view of the above, the matter stand adjourned. List this matter after 2 weeks. Okay.
Sir, and my Lordship, I also like to mention the item number 21, sir, for adjournment.
21, let us see the record. Okay. We'll grant you adjournment, but wait for some time. Okay, we'll see the record. What for it has been listed.
Deeply obliged, sir.
May I please, my lord?
Yes.
My lord, I'd like to mention item number 32.
Thirty-two.
32, yes, my lord.
Yes.
Yeah, my lord, the learned APP, Ms. Jeannie, she has informed that she has some personal difficulty. I am for the petitioner, my lord. So, maybe this may be adjourned for 3 weeks.
Ms.
my lord.
Is okay. Land council for the petitioner. Praise for adjournment of the matter. For
Well, since, no, in fact, Miss Jeannie was supposed to make the prayer, but she called me up and then she informed me that she has some personal difficulty.
it's okay. Submits that Miss Jeannie, land additional PP for the state has some personal difficulties today and requested him to make a prayer for adjournment of the matter for 2 weeks.
3 weeks.
3 weeks. The prayer is allowed. This matter after 3.
There's
Okay,
an
3 weeks.
interim order, madam.
The interim order passed earlier shall continue till the next date of listing. Okay.
Always.
Item number 1.
May I please, Lordship?
Hmm.
Lordship, this is a bail application in connection with Likavali PS case number 21/25 under section 64 clause 2 VNS and POXO 4 clause 2 and 8. Lordship, may I kindly call for the records. This case is already charged sheeted here.
Charge sheeted?
Yes.
Okay. Mr. D.
Here, Your Worship, there is two informant. One is mother, both of other informants are mothers, but name reflected in the cost letter is two is good. He's something. Third one is not a party. Third one is a minor borough, mother of some Miss X Y.
Informant.
Proxometer, yes. That should be corrected. Third one. Informant.
No, two victim.
Two victim. And both,
then
both
informant.
of victims are, mother of the victims are informant. But one mother is named adversely. Another one is that has to be amended.
There is a different name.
Yes.
Yes, Lordship. Respondent number.
On Moina, but it is.
In the meantime, I will correct the Lordship. Kindly call for a record.
And there is a participatory right in the proxometer. This is a proxometer of the informant, either victims. Victim is a minor, so their legal guardian will be represented. Without serving cause of serving of notice, it shall not be taken up. Even if, since from the inception of the FIR, they have a participatory right.
Yes.
Let service may be completed. Thereafter, record may be called for.
Mr. D. Soikia, Land Council for the petitioner. This is an application filed under section 483 of the BNSS 2023, seeking release of the accused on bail who has been arrested in connection with Likavali PS case number 21/2025 under section, it's 64.
64, Lordship.
64(2), within bracket 2, within bracket M, BNSS. What is this? BNS.
Lordship, BNS.
2023, read with section 4, within bracket 2 and 8 of POXO Act 2012. Stop. What did you submit? First, notice is to be complete.
Yes, notice has to be complete because there is a clear direction from the Honorable Supreme Court.
We'll call for the record also, but then unless they appeared, we will not hear.
No, by then, trial may be continue. By then, maybe prosecutors may be examined also. By this time, at least by now, it should be kept in evidence for a calling of the record. And let step may be taken. Amendment has to be done also in the response number 2 in case of.
Mr. Saikia, Land Council for the petitioner, prays for allowing him to correct the name of the respondent number 3. The prayer is allowed. Start. Issue notice upon the respondent. Since, no, Mr. Tado, G. Tado, additional PP appear on behalf of the respondent and state respondent. No formal notice be issued. However, the petitioner shall take steps upon the respondent number 2 and 3 by a registered post with AD as well as by usual process within a week, within 2 days from today.
3 days maybe.
3 days from today. Stop. Huh? Let this matter be listed after 2 weeks.
Yes, 2 weeks. If it's sub, if it is not sub, then automatically it may be deferred also. 3 weeks.
Lordship, 2 weeks. 2 weeks will do.
2 weeks. Okay.
No dusty service in this matter. No dusty service.
Okay. This is matter after 2 weeks. Okay.
Obliged here.
Item number 2.
May it please your Lordship. Lordship, this is a joint application filed by the petitioner under section 528, praying for the quashing of the FIR dated 06 January 2020. Lordship, here the petitioner number 1 is the complainant come wife of the petitioner number 2, and petitioner number 2 is the husband come alleged accused. Lordship, the nature of the accusation is Lordship 376, punishment for rape. It is Lordship uncompoundable, non-bailable. Imprisonment is minimum 10 years. Now, second section is Lordship 417. It is a simple cheating. Lordship, it is compoundable, bailable, and imprisonment is only 1 year. It's non-cognizable. Therefore, Lordship, my only humble prayer is that TCR may be called upon, and until the admission, interim may be granted on the proceeding. Lordship, this is a charge-sheeted matter. The matter is pending before Honorable Learned District and Session Court.
What is the status of the trial?
313 has been completed. Now
313 also completed.
Yes, now
How
That means is the verge of conclusion of trial.
it was delay. We have prayed for the defense witness, Lordship.
313 also completed.
Yes, Lordship.
Now it's hearing not yet done.
Lordship. Witness.
What remains then?
No, Lordship. They have made delayed the parties, and already they are married since long back only, and they are out of their wedlock. They have children also. It's a marital, Lordship.
Appears in page number 19. FIR. Written blue and black. Non-compatible offense are compromised by this Honorable Court, High Court, when in 3 stages. When it was filed before the charge sheet, after charge sheet, charge was framed, and during the trial, but it is on the verge of the conclusion of trial.
It will be difficult.
Yes.
At this stage. Because what remains is only here.
Only judgment remains.
No, Lordship, there is a defense witness still yet to be examined, Lordship. Defense witness is there, Lordship.
Last sentence of past para. There's the intention was purely last sentence of past para.
It is to inform Lordship, prior to the filing of this FIR, they were living together only. Out of some, it is very clearly mentioned in the FIR agreement that out of some misunderstanding, the FIR has been lodged.
Now you see at the last stage, when you have seen that the case is going against you and you're likely to be convicted, then you have entered into an agreement. This is October, recently, very recently. So till then she was not agreeing.
No, they were living together only, Lordship. What happened is that they are.
But did not agree.
No, they have a children also, Lordship. Here they have made delayed. That was the default only. Otherwise, there is no issue. They are living prior to the filing of the FIR. Lordship, I'll submit very fairly. Prior to the filing of the FIR, only they were living together.
So we'll see the record, Mr. Tadab. We'll see
Yes,
the record.
record may be called for.
Mr.
As in Lordship.
S. Ingti, Land Counsel for the petitioner. Tara, this is a joint petition filed by the informant and the accused in Ita Women PS case number 01/2020 under section 376/417 of IPC. Corresponding to session case number 14/2022 pending before. No. Seeking quashing of the just a minute. Joint petition filed by the the informant and the accused in so and so case under section 528 of BNSS Sanita, seeking quashing of the session case number 14/2022 in arising out of Ita WPS case number 01/2020 under section 376/417 of IPC. Stop. Call for the just a minute. WPS number pending before the court, session court. Which court?
District and session.
Session.
UPIA.
UPIA. Stop. Tara. Call for the case diary. Issue notice. Not case diary. Trial court record. Issue notice. Since Mr. Tadu, then additional PP has accepted notice on behalf of the state. No formal notice need be issued. Okay. List this matter after 2 weeks.
Okay.
Lordship, interim prayer.
No.
Because okay.
Prosecutors need to take them.
Item number 3.
May I please, Lordship?
Yes.
Hello, this is a pension matter, my lord.
Okay.
Hello, petitioner was retired on 31st May 2025 on attending the superannuation, my lord. So thereafter, his controlling officer has forwarded his pension papers and service book to the respondent number 1 for settlement of pension, my lord. My lord, the main issue which is before your lordship of consideration is that, my lord, what happened, my lord, in the year prior to year 2003, my lord, the junior engineers under the various department of state of Arunachal Pradesh, my lord, they are covered under ACP and thereafter MSCP, my lord. But after 2003, my lord, by an order dated, my lord, 35/2003, my lord, this ACP and MSCP has been, my lord, removed, my lord, and it is supplemented by time-bound scale, my lord. Time-bound scale, my lord, is like that, my lord. In order to, my lord, check the stagnation of the officer to promotion to higher post, my lord, time-bound scale is given, my lord. First time-bound scale is given is 12 years, thereafter 24 years, my lord. What even, my lord, when this 2003, my lord, order was issued, this petitioner was already
promoted to the post of assistant engineer, my lord. And his, my lord, pay, my lord, was regulated under ACP, my lord. Accordingly, my lord, this on my lord, on regulation of this ACP, my lord, his initial pay scale, my lord, his pension papers has been, my lord, forwarded to the respondent number 1 for settlement of pension, my lord. But the contention of the respondent number 1 is that, my lord, since, my lord, the petitioner was junior engineer, and thereafter he was appointed, promoted to the post of assistant engineer. Therefore, my lord, this ACP or MSCP will not, my lord, it's not, my lord, provided to the petitioner. He will cover under time-bound scale, my lord. That is the issue in this case, my lord. My lord, may I take your lordship to first, my lord, page first, my lord, I will take your lordship to page 31, my lord. Page 31, my lord, annexure 3. My lord, this is the pension papers and service book of the petitioner, which was forwarded to the respondent number 1, my lord. Here, my lord, every, my lord, particulars which is required under the, my lord, formal settlement of pension, that has been forwarded, my lord. There, my lord, it will be not much, my lord. So I will not read out this whole list, my lord, contents, my lord. This is only, my lord, pension paper with details of particulars which has been forwarded to the respondent number 1, my lord. My lord, next page, my lord, page number 33, my lord, annex 4. My lord, this is the observation which has been made by the respondent number 1, returning my pension papers and service book, my lord, which is page 33, my lord. This is 7 July 2025, my lord. Your lordship got, my lord.
Yes.
This is 7 July 2025, my lord. My lord, kindly come to my lord, paragraph 1, my lord, Roman 2. My lord, there is other issue, my lord, that can be sorted out. My lord, this is the main, my lord, issue, prime issue, my lord, which has to be, my lord, delivered by, my lord, which has to be, my lord, delivered this honorable court, my lord. My lord, Roman 2, my lord. May I read, my lord? Also, as per latest clarification dated 28 to 2025, copy enclosed, received from Administrative Reform Department, Government of Arunachal Pradesh, the junior engineers promoted to assistant engineer are not covered under SCP/MSCP scheme, as they are already covered under the time-bound scale. Hence, the officer will not be eligible for second or third MSCP. Instead, the officer is to cover under the time-bound promotion scheme and granted second time-bound scale on 5/9/2008 in GP of 660 and pay fixed under provisions of FR such and such on completion of 24 years of service. Hence, pay may be re-regulated accordingly and excess drawl recovered into the government account with an entry in service book, duly enclosing the recovery details and due drawn from the same, my lord. My lord, they are contending that I am not entitled to SCP or MSCP, but I am covered under time-bound scale, my lord. Thereafter, the next page, my lord. My lord, the reply, my lord. I will say my resubmission. After return of my pension paper and my lord, service book, it was again, my lord, resubmitted, my lord, by the superintendent who is respondent number 4 in this case, my lord, page 35, my lord. After more observing, my lord, after clarification of all the observation which has been, my lord, made in this letter dated 7 July 2025, my lord, this again, my lord, my pension papers and service book has been, my lord, resubmitted by the respondent number 4, my lord. My lord, I will come to the main point, my lord. My lord, kindly down below, my lord, Roman 2. Down below, my lord. This para 1, Roman 2, my lord. Down below. The incumbent was promoted as Board. The incumbent was promoted as AE on 22nd 08/1994, according to the government order number such and such dated such and such. And he was no more as junior engineer, while the time-bound stay implemented with effect from 1/6/2003 by government order number such and such dated 30 May 2003. And also government of AP finance memo number such and such dated 11 March 2004. Both the office memorandum and order said that the TB is applicable to serving junior engineers only. Copy enclosed. Yes, my lord. My lord, thereafter, my lord. My lord, again, my lord, on my lord, in page 36, my lord, annexer 6, page 36, my lord, my pencil paper and service book has been again, my lord, returned, my lord, by the respondent number 1 to respondent number 2 with certain observation, my lord, which is they have made again and again same observation in spite of this clarification, my lord.
Okay, what is your prayer then?
My prayer is, my lord, in this stage, my lord, since this issue is regarding, my lord, the applicability of this, my lord, ACP or my lord, time bound scale, my lord, let notice be issued today, my lord. But my lord, short date may be given, my lord, since this is a pension matter, my lord, short date may be given, my lord.
Okay.
Yes, Your Lordship, notice may be issued at this stage.
Mr. H. Lampert, Land Council for the petitioner. Also, okay. Ms. Sangeeta, Land Government Advocate appearing on behalf of respondent number
1, 2, 3, Your Lordship.
1, 2, 3. There are only 3 respondents.
No, there is
Okay.
4, my lord.
4 also. You are 4?
On behalf of he is on behalf of respondent listening problem, L farming, my lord, standing council.
Land Standing Council for the respondent number 4. Okay. Okay. By filing this petition, the petitioner is seeking direction to the respondent number 1, that is the Director of Audit and Pension, Government of Arunachal Pradesh. To settle the pension papers and service book of the petitioner in terms of the government order number PWRS/E 953/2003/232 dated 30/5/2003 and Government of Arunachal Pradesh Finance Memo number ESTT2 Roman 2 2000 2022/215/2022/215 dated 11/3/2024. Amongst other seeking direction. Okay, start. Issue notice. Since Ms. Sangeeta appear and accepted notice on behalf of respondent number number 1, 2, and 3, and Mr. So-and-so for respondent number 4, no formal notice need be issued. However, the petitioner shall furnish requisite extra copies to the Land Council appearing on behalf of the respondent within 2 days from today. Start. List is matter after 3 weeks.
3 weeks,
Okay.
obliged, deeply obliged.
Item number 4.
My lord, I never came across a situation where a person is appointed by due process of the recruitment, then regularizes, my lord, and thereafter petitioner is transferred to the posting place, and pertinently the controlling authority don't accept the joining report. I don't know from which law they are preventing the petitioner from joining, accepting, joining, and her joining report is not being accepted, my lord.
Accepted by, not been accepted
Yes.
by the.
So very unfortunate, my lord. This is a situation where it is a flagrant violation of equality before law and Article 21, my lord. And we see
Has
that.
it been communicated to you that?
Well,
joining
just
report has
I,
been accepted?
just I will indulge, my lord, with the annexures.
Okay.
It was very surprised to see. My lord, kindly, my lord will flip over to the annexures first. Page number 38, 28 to 30, my lord. That is dated 27/7/2015 and 25/7/2016, where I have done my BSc nursing and then my enrollment with the Nursing Council of Arunachal. Then, my lord, see, kindly come to annexure 2, page 31, my lord. And page 33 would be the most effective page, my lord, which I want to refer.
Yes.
My lord will see the advertisement,
Okay.
page 33. For GNM nursing is there. Nursing officer post is there, my lord. Now, my lord, kindly come to page 37. This is the select list which they have prepared. Now, my lord, see kindly page number 37, serial number 100 is my name.
Page 37?
37, my lord.
No.
No,
37 is something.
sorry, 39, my lord, sorry. Page 39. Huh? I have mistakenly written here. Human error, my lord.
Serial number?
100, my lord.
Okay. Now, serial number 100?
Yes, is my name.
Okay.
Now, my lord will kindly come to the appointment order pursuant to that. 22/11/2016, page 41, I was appointed. Huh? At serial number 10, my lord. 4? Serial number 4, my lord. Page 41, serial number 4, I am appointed, my lord.
Yes.
Now, thereafter, see, my lord. Then, copy of transfer and posting order, page 45. 25/5/2023, I was posted.
Okay.
Now, here, my lord, page 45. In the interest of public service, the Arunachal Pradesh State Health Society is pleased to order the mutual transfer and posting of following nursing officers, contractual staff working under National Health Mission with immediate effect. My lord. I stands at serial number 1, and number 2 is the another nursing officer with whom I have exchanged the posting place, my lord. Now, thereafter, my lord, kindly come to page 47, my lord. Annexure 8, my lord. Annexure 6, my lord.
Yes.
I was regularized, my lord. My services was regularized as nursing officer. DPC dated 25/7/2025. And my lord, I stands at serial number 256 at page 47.
Yes.
Now, my lord, the unfortunate problem started from here, page 51, my lord. I don't know whether state is very mindful of their actions or not. But to my mind, my lord, this is not to be done in such a manner, my lord. Page 51, my lord, kindly see. Page 51, annexure 7, dated 10/7/2025. My lord will see joining report, medical superintendent, government hospital, Konsa, district chair of joining report. with due respect, I am submitting my joining report today, that is 10/7/2025 for noon as nursing officer, right appointment letter dated so and so, issued by the Department of Health and Family Welfare, Arunachal Pradesh Civil Secretary. Now, my lord, after the handwriting part, my lord, after the handwriting part, bottom, my lord, see, after serial number 11, my lord. There's a handwriting joining. Huh? Joining, my lord. Just kindly come to next page, my lord, the type copy. Page 53, my lord. Page 53, my lord. Joining, repeat, kept in abeyance till further order from higher authority. Now, my lord, what kind of situation is this? Kindly appreciate the predicament of a person, of an officer. First, my lord, I have not come by the back door, number one. Number two, recognizing my sincerity and performance of duty, you have regularized me. And thereafter, there was a mutual transfer with my colleague. And then when I am supposed to join there, and within 15 days, I was asked to join, and I joined it. But this medical superintendent sarcastically is not accepting my joining. Now, the question of law is, mother, from where he has drawn this power? Thus, this medical officer has extra constitutional power to deprive me of my fundamental right. If that is not be the case, so, my lord, this is a feed case where my lord will direct the respondent authority, especially 6, the medical officer, medical superintendent, to accept my joining report, number one. And, my lord, here, the second question of law that will fall in would be the concept of no work, no pay will not come, because this is an arbitrary and malified exercise of the power by the medical superintendent, wherein my joining has not been accepted, my lord. Such be the factual circumstances, my lord, is a case for kind indulgence and interference by this honorable court under 226 to do the complete justice and equity, my lord. You cannot play with the life of a person, my lord. Therefore, my lord, the second count which I have proposed is on the proposition that no work, no pay concept will not come, because it is your deliberate and malified intention that you have diverted me. And I am a lady, my lord. You do not have this power. You do not have the carte blanche to exercise the power in this arbitrary manner, my lord. Or otherwise, my lord, if I say in a lighter vein, you are just making me to make a window shopping in the castle of Chinatown. This is, my lord, I don't agree with this. My lord, yes. Thereafter, my lord, I have submitted, I finished it. My brother Tagom will say something. Thereafter, my lord, I have submitted series of representations.
Yes, yes.
Even these representations are not being attended, my lord. Because I do not see any caste, creed, or religion in this matter. What is there in the law, it has to be followed. That is, my lord, that Mohindra Singh Gill case. Procedure so established. That is celebrated constitutional judgment of this the Honorable Supreme Court, which is widely followed. If you have established you have to act in accordance with the procedure so as established, then where is the impediment? Otherwise, you are misusing the power. Now, my lord, this has all the representation, my lord, kindly see. I have submitted on 17/7/2025 to the commissioner, then the director, and so forth. But it's okay. But there is no response, my lord. So, my lord, only the prayer that I am making today, my interim prayer, my lord, before my brother comes in. But kindly come to page 24. This is my interim prayer that I am proposing today.
Yes.
In the interim pending admission, hearing, and final disposal of the rule, it is most humbly and respectfully prayed that this honorable court may be pleased to stay the operation and implementation of the impugned notation dated 14/7/2025 made by the respondent number 6, keeping the petitioner's joining report in abeyance pending the hearing and final disposal of the instant read petition. First. Second interim prayer is direct the respondent authorities, my lord, to forthwith accept the petitioner's joining report dated 10/7/2025 and allow the petitioner to discharge her duties as nursing officer at her posting place, Government Hospital, Konsa. Then C, my lord, direct the respondent authority to release and pay to the petitioner her monthly salary, emoluments, allowances, and all services benefit in pay matrix level 7 with effect from 10/7, so and so. This is a fit case, my lord. You cannot, even, my lord, for an appreciation under the CCA rule 1965, no rules, my lord, provides that reporting authority cannot accept my joining report. Is there any violation of the CCS rule? Respectfully, no, my lord. I don't have committed anything that will attract the consequences of the CCA rule, my lord. That therefore, my lord, what my brother Tagum will say that I don't know, my lord, subject to the request and the prayer that I made before the lordship is to consider my interim prayer today.
Yes.
My lord, before clarify, my lord, first, my lord, see at page 33, my lord. Page 33 of the writ petition, my lord. This is the advertisement on the basis of which the petitioner was appointed as a contractual nursing officer in the NRHM, my lord. This is the advertisement, my lord. Advertisement, my lord, you see the language of advertisement. Application in prescribed format is invited from citizen of India for recruitment, citizen of India. Now this advertisement is for the citizen of India, my lord. Now later on, my lord,
That will come, that I'll clarify.
my lord, on the basis of this advertisement, he submitted certain document, PRC, my lord. And on the basis on that, my lord, he was appointed, believing that he is a citizen of, she is a citizen of India, my lord. Thereafter, my lord, through process, although she was regularized by dated 27 May 2025, as it has been shown, my lord. But later on, after this regulation was issued, regulation order was issued, there was the high-level committee was constituted, my lord. High-level committees on the ground that there was a complaint from the various section that this, how come this, the person has come into, has been appointed regulation, there's certain query was made. And on the basis of that query, the high-level committee, the government has constituted a high-level committee. The high-level committee, they have confirmed that on the basis of which his her first appointment was done, it was based on one PRC, man, permanent residential certificate, man, which was not issued by the competent authority. And this regard, after having confirmed that this was done on the basis of the certain PRC, the authority, they have made a confirmation with the concerned deputy commissioner. It was confirmed that it has not been issued by them, and it is invalid, my lord. So having come to this fact, my lord, ultimately this entire she was not eligible at all, because first thing, it was citizen of India, and her citizenship is still, my lord, she's not a citizen unless and until the document is clear, my lord. So that the higher level.
Any action initiated?
My lord.
Any action initiated?
My lord, after detailed inquiry, we are placing it to the government authority, because government initially they have constituted a high level committee.
Regarding, because she was already appointed.
Yes, appointed. That's why, my lord, inquiry has been done, and whatever inquiry and also the confirmation.
Whether that was communicated to the petitioner?
My lord, will be communicating, my lord.
Okay.
Because
not yet.
Not communicating. Word communicating.
My lord, that whatever the ground report, it has been done, my lord, carried out. We are placing it to the government, and after getting confirmation from the concerned deputy commissioner, my lord, we are placing it, my lord. That's why, my lord, this is serious matter, my lord, because of that
So you have not yet initiated anything against the petitioner with
My lord.
regards to her citizenship, right? Citizenship.
My lord. My lord, because the detailed inquiry is going on, my lord.
But then.
Because it's confirmed, my lord, this is from the confirmation of Deputy
But
Commissioner.
yes, there is no reason, only joining report kept in abeyance.
My lord, because there.
No reason assigned.
My lord, that reason, my lord, I'm just telephonically, I've just obtained the instruction on this regard, my lord. Her joining report was kept in abeyance on the basis of the inquiry done by the high level committee, and it was telephonically, it was even in written. This authority was
Telephonically informed to the superintendent of.
Yes, no, even officially also, in writing also, it was intimated to the superintendent, medical superintendent, not to accept, because there's a high-level inquiry and there's a prima facie case that he's not a bona fide candidate, and wrongly it has been done, my lord. But anything it has been done in fraud manner, my lord, it wasted everything, my lord.
But you see, you did not do anything against her.
That is why, my
Not
lord.
initiated, you are not paying salary also.
My lord, that part I
without any order.
My lord, that part, whether salary it has been withheld or not, but that part I have no instruction. But regarding the non-acceptance of the joining report, my lord, that is from the authority, government authority, my lord. They have confirmed it, my lord. So in my respectful submission at this stage, my lord, the notice may be issued, my lord, because ultimately, my lord, what I'm submitting, ultimately, if we succeed, my lord, if there's no case, he will get all back wages, my lord. There's no issue. But the thing is that, my lord, it's found to be a very sensitive issue. Ultimately, he will succeed. Even assuming that she's not been paid with the salary also, they will get back wages. Everything will get after this, my lord. Means there's a serious matter, my lord. The high power committees they're looking into the matter.
My lord,
Okay, we'll issue notice at this stage.
no, my lord. Just because
Let them file.
No, my lord. Please give me 2 minutes. I'll clarify.
Let them file affidavit, what I'm saying.
That's fine, my lord.
Apparently.
Just I'll rebut all his contention here itself, my lord, from the record. Number one, will kindly see page.
No, that I've seen.
Page 39, my lord. I have come from the general category.
My lord, that is a citizen of India.
Sir, please wait. Sir, please wait. Your advertisement says citizen of India. Now, where he is faulted by himself, the submission of the my brother standing counsel, page 70. I don't know what kind of inquiry they have conducted. I think everything is built in the air. So let not there be a hanging breeze. At least it should have a concrete road. Page 70, my lord.
Okay. Electoral photo.
This is my electoral identity card, my lord. 72 is the type copy, my lord. My lord, see my name and the first 72. Then title, then name, father's name, then last relative name, then age, female, epic number, so and so, Assam, my lord. Assam. And kindly see next, my lord, number parliamentary constituency name, 5 Guwahati. Then constituency number, assembly constituency number, 36 Central Guwahati. And my lord, kindly see polling station number is also given. Then part number is also there, serial number is also there, no election schedule currently. I am a bona fide citizen of India. Otherwise, my lord, even on morality, I would not have taken up this case. One, my lord. Kindly see, my lord, why I am pressing for the interim order. My lord, kindly see. If a person, which my brother says, fraud, BCS, everything, I do concur the view. But at the same time, fraud necessarily is not the root cause of punishing a person in this manner. If, my lord, if a person by means of fraud has obtained a particular job, in that case, what is the law for you? Is Article 311. Then Article 311(2) protects me. Thereby the CCA rule will come. My lord, my brother has categorically made a submission being communicating. And if there is any communication, why you have not provided? Therefore, my lord, kindly suspend this. You cannot do this.
We'll bring it on record, everything.
You file your affidavit.
Mr.
so
Titi Tara, Learning Counsel for the petitioner. So the petitioner is aggrieved, being aggrieved by
fact, correct.
the impugn note made by the medical superintendent keeping her joining report in abeyance till further order from higher authority staff. Para. The case of the petitioner is that
My lord, my synopsis may be taken into service if my lord don't kill otherwise.
being qualified, found qualified for appointment. She took part in that. There was an interview.
My lord, yes, I have faced the interview.
Appointment for
Nursing officer.
nursing officer.
Contractual, my lord, under NRCHEP.
Under NHR. No, afterwards it was released.
Staff nurse or nursing officer.
Later on, as a nursing officer, my lord, that was redesignated.
Okay. Okay, qualified in the interview for the contract nursing officer. She was appointed as nursing officer and posted at PHC Kain.
Yes.
Under National Health Mission at the fixed monthly remuneration of rupees 20,200. After serving for about 9 years as nursing officer, her contractual service was regularized by an audited. Her contractual service along with the others were regularized by audited on 27 May 2025.
Pardon, my lord.
Regularization is
Regularization, my lord.
27/5.
27/5, correct.
Okay.
Page 47. 46 is the order.
2025. And on being regularized, she has submitted her joining report before the respondent number 1. No, respondent number joining report before the respondent number 6.
6, yeah.
Okay. However, her joining report submitted her joining report before the respondent number 6 on time. However, her joining report has been kept in abeyance, has not been accepted, not been accepted till date.
And also salary is not being paid.
Nor her salary being paid. Staff. Not been accepted, huh? without any reason, without assigning any reason.
Any reasons?
Her salary has also not been paid till date. Stop. Thereafter, she made several representations. However, so the same has also not been attended. Stop. Issue notice. Since Mr. Who appear for the state? Okay. Okay, appearing on behalf of the respondent number? One. And Mr. Togum for respondent number?
All the-
226, my lord.
all-
Rest.
all the rest, all the rest.
No formal notice need be issued.
Three zeros.
However, the petitioner shall furnish the requisite extra copy of the petition to.
My lord, my brother says he will Xerox and send it. It
My
must be correct.
lord, I never said that. I never said this, my lord.
Within 2 days from today. Okay. Within 3 days from today. Start. List is matter after
4 weeks, my lord.
4 weeks. Start.
अभी नहीं वो नर्सिंग में किया था.
It is made clear that, oh, sorry, however, it is made clear that there is no, so during the pendency of this writ petition shall not be barred to the respondent to dispose of the various representation submitted before the respondent authority. Okay.
My lord, I have a specific prayer, my lord.
No, this.
My lord, why I am saying, my lord, a person is being harassed for no reasons without giving a plausible reasons for not accepting my joining report. Meaning thereby, there is a straight jacket formula of violating Article 14 and 21. My lord. Kindly see. So, prima facie, there is a material to show that mandate of Article 14 and 21 is violated. One. Therefore, my lord, unless this notation on my joining report by respondent number 6 is not state, they will not.
What will do?
They will not.
What
they will
will
not
do is then pending disposal of this writ petition, the respondent authority is directed to dispose of the representation.
Yes, my lord.
Various representations submitted by the petitioner within 3 weeks
My lord.
from today and pay the salary if she is entitled.
My lord.
Okay.
My lord,
That will do, my lord. That is fair enough.
My lord, why I am saying is, I am praying for a pliable lady who is suffering. Kindly see, there are so many sufferings in the world, but sufferings inflicted by officials in violation of the law and the procedure established thereon cannot be sustained. Therefore, my lord, that notation need to.
My lord,
One more thing, because her earlier service.
My lord.
That was not
9
disturbed.
years.
My lord,
Not disturbed.
my lord, that is why, my lord, that's entire equation is.
Nothing.
My lord, that's
No
why.
reason, nothing.
My lord, that is why entire equation is being reviewed.
At the moment,
My lord.
unless that is removed,
My lord.
at least you could also pay the
My-
salary.
My lord, that is why, my lord, entire equation we are reviewing, my lord.
That is why you did not do anything because it was.
Even DPC.
My lord,
She submitted her joining report when?
my lord, that,
Way back in the month of
my lord,
July.
that's, I do accept, my lord, this part. This fact only come into light, my lord, when this regulation was done and it was placed in the surface in the public domain, my lord. It was only come, and then only on the report, my lord, inquiry committee was constituted, high-level inquiry committee, high-level committee was constituted and examine it. My lord, that is, my lord, that which earlier, my lord, proposed to pass, that will be fair enough, my lord. Because ultimately, but whatever reason we have undertaken, whatever thing we have undertaken,
my lord, with
still we
greatest respect,
we'll bring it on record,
my lord, with
And so-
greatest respect,
No.
I beg to differ with the submission of my brother for the reasons that this is relating to my joining report.
My lord, my
and
respectful
non-accept-
submission.
No,
No,
not
one by
accept-
one, please.
No,
Just a minute.
the least before this honorable court at this moment is non-acceptance of my joining report.
My lord,
You cannot bring in other facts here.
my lord,
The
my
question
lord,
is,
my-
let us decide. If you have some material prima facie against me, then that is subject to a disciplinary proceedings. and the consequential termination of the job.
Madam, that is
You
why
do
that
it.
we-
You
we-
do it.
Yes.
I am not saying
That,
do
that
it.
is part, Madam.
But here you cannot. Here you cannot. With
Madam-
greatest respect, my lord.
That is.
Whatever, my lord,
No, my lord. That's,
whatever,
no,
whatever
I,
is entitled.
my brother
entitled
has been
for,
very
she will
rational.
get
My-
everything, my lord.
My brother
Madam,
has been very
only
rational
this.
in all his submissions, but today I respectfully disagree. This is not correct. Not correct.
My lord will bring it on record, my lord. Ultimately,
file, you
next
file.
day,
You
we,
file.
we are
If
also
it is
because
there,
there's.
Ensure that by the.
My lord, yes,
next-
my lord.
By the next date,
We are,
file your affidavit.
my lord, we are also equally
Otherwise,
concerned, my lord.
We will be
Yes,
compared to
madam.
direct to pay all the
Yes, madam.
salaries with all the benefits.
My lord, my lord.
Okay.
Deeply obliged. ma'am.
Well, that notations, my lord, kept in events. Kindly suspend that. Whether
My
after,
lord,
well,
that is-
after
We
see,
do not know why it was.
That is why.
no,
my
no,
lord,
no,
We
my
don't know.
lord,
That's
no, no.
why let us see. Let us see.
That's why, my lord, I am respectfully submitting before my lord is on a simple count, my lord. In the service matter, my lord, in the service jurisprudence.
Directed to dispose of the representation.
No, my
The
lord.
representation
Representation,
wants to know
no, my
what
lord.
was the reason for
My lord,
keeping the-
representation, my lord.
giving your
No,
joint
no.
report?
My lord, representations, I have filed series of representation, fine, my lord. And this has not been attended to till today.
That is why my lord has directed.
Well,
my lord.
then, my lord, that's why. Until then, my lord will say,
Also to pay salary
Yes.
if you are entitled.
Yes, my
my
lord, that's fair
then
enough.
Till disposal of the rule, no coercive action, that's all. Kindly mention that, if anything, because they have brought something beyond my imagination and beyond my knowledge.
What kind of coercive action you are expecting beyond this?
Well, they say, scheme, my lord, they have constituted a departmental inquiry
But that will
committee.
give, he will
They
she will
have-
be given
No,
equally
no.
opportunity. He will
She said, my lord,
afforded-
he has already submitted that is being communicated. I do not know.
No.
I do not know what kind of thing you are doing against me. Because I
Let
have,
us see on the next step.
Let's be come up with our clear picture, my lord. That's-
Yeah, let's come.
no, then like, for the interest of justice, my lord, I am requesting once again, my lord, kindly, I am beseeching my lord to have a rethinking on the interim order. For the reasons, my lord, see, service jurisprudence has two count, my lord. The firstly, your recruitment, appointment, and the joining. This is one part. The second part is, if any job is obtained by means of fraud, or secondly, if a person is arrested in a criminal case and he has been put behind the bar, within 48 hours, he is deemed to be suspended under Rule 10.
No, another-
No.
what we have submitted as
That's why. Number 3, my lord, if during discharge of the official duty, if he commits or conduct in such a way that it becomes detrimental for that person to be remain in the office, then there is a disciplinary process. Now, in this case, disciplinary process would amounting to the following of the principle of natural justice. One,
Madam, that
you
is
have to
we-
serve notice.
You have also come
That's-
after 4 months.
I
So that
That's-
is
no,
why-
I agree.
2 more weeks. 2 more weeks.
No, well, I respectfully bow down what is falling from my lord, but my lord, kindly see the predicament as well. Because see, if my argument doesn't convincing, my lord, I'll not press on. But the equity which has fallen from the Chancery of England, where we are following it, my lord, should also be applicable in this court. That's why. 2, they have not served me any so cause notice. See,
That is, we wanted to know.
my lord, that's why I have not brought Jharkhand judgment is there, 2010 judgment. It says necessity of giving reasons. Every administrative action must be in consonance with the rational nexus. And when there is no nexus,
See, like
here,
Mr. Tara, the Lana responsible Lana Standing Council has submitted raising question regarding your citizenship. So I have no reason to disbelieve him also at this moment.
I am not saying, Lord.
2 weeks.
I am not saying.
2 weeks time.
Ah.
In 2 weeks time, it will be clear.
My lord.
Well,
Well, then one line, my lord. I am requesting one line only. In the interim, my lord, in view of the submission made by the standing council
Hmm.
that he is not a citizen of India,
Hmm.
her appointment shall be subject to the.
No, that is only, my lord.
Then you cannot make submission, my lord.
No.
His submission cannot be accepted in that event.
No.
Because here the lease before my lord is only to an extent of not accepting my joining.
See, I have directed to dispose of the representation, various representation submitted by you before the competent authority to dispose of within 2 weeks. We'll say, of course, with a speaking order. I'll add that.
By means of speaking order, by giving a reasons.
Obviously.
By giving a reasons.
Obviously, my lord.
Okay.
But if it's something similar.
And then she will be paid if you are entitled.
Yes.
After examination. Okay.
My lord.
Well, I don't know anyway, because what I find is, what they have done is, number one, they are not following this Article 311(2). You do whatever you want, because I have prima facie demonstrated that I am a person from Guwahati. My voter list is there. And this is also no reason for my lord not to believe it.
Okay.
My lord has been.
Okay.
Item number 5.
Lordship, may I please?
Yes.
Lordship, here I'm aggrieved by the order dated. Lordship, may I kindly come to page number 16, Lordship. 17, Lordship. Lordship, my name is here in serial number 4, Lordship.
Yes.
Lordship,
What is it?
through this notice, Lordship, I was relieved from my service
Okay.
by stating that I have attained the age of 60 years, Lordship. However, Lordship, factually this is incorrect. As Lordship, I have annexed my birth certificate. Lordship may kindly come to page number 18, Lordship. This is my birth certificate, Lordship.
This was obtained 2015.
15,
You were appointed in the year 2007.
2007, Lordship.
In the 2007, what your age was recorded by the government? What
Lordship-
document you have given to the
Lordship, that
government?
was-
It was recorded.
Lordship, that
And
was-
this is subsequent obtaining.
Lordship,
Subsequently, you obtained this birth certificate
Lordship,
in the 2015.
that was based on Aadhaar card only. That was discrepancies. That was already corrected, Lordship.
Where?
When, Lordship,
Where is the application for correction?
Lordship, that was not submitted to the respondent,
Okay,
Lordship.
then?
However, this,
See,
Lordship, but the Aadhaar card cannot be relied as the,
it cannot be relied upon. In other card, you look like 65.
Lordship, that is already corrected, but the birth certificate is the exact record through which it can be relied, Lordship.
See the other card.
Yes, that was already corrected, Lordship.
This was obtained, other card was obtained when?
So that is not mentioned here. Lordship, my birth certificate and my AP card, in both the this card, my birth certificate, my date of birth is.
See, yes. Can we issue notice? Okay, we'll issue notice.
Let's see.
Mr. D. Sakya, Land Council for the petition. By filing this writ petition, the petitioner had challenged it's circular or order?
Lordship, it's circular, Lordship.
Of its circular dated 24/4/2025. Whereby the respondent, who is this, who has issued this? Respondent number?
Lordship 4.
Respondent number 4. Relieving the petitioner from his contingent service.
Lordship.
contingent service after on attaining the age of 60 years. Stop. Huh? Okay. It is submitted that the actual age of the petitioner is what is your age? You said
Lordship, I am 43 years.
43 years, being
3 months.
born on 1/1/1982. And not on 25/1958 as recorded in the department in the impugned order. Stop. Huh? Okay. Issue notice. Returnable by 4 weeks. Since Ms. Pango accepted notice on behalf of all the respondents,
Yes, Your Lordship.
all the state respondent number 1 to 4, no formal notice need be issued. Stop. Huh? However, the petitioner herself furnished requisite extra copy to the Line Council for the government advocate within 3 days from today. Stop. Huh? Para. List this matter after 4 weeks. Okay.
Item number 8.
I am for the respondents minute. I need some time to file affidavit minute.
Okay. Mr.
S. Botakumar.
Mr.
In Ukatama, my name is Jamil.
Line Council for the respondent number.
All are respondents, 2 respondents, BPC. minute.
Okay. So okay, Line Council appearing on behalf for the respondent prays for further 2 weeks time to
Yes,
file
ma'am.
affidavit in opposition. Stop, Mr. D. Pange, Line Council for the petitioner is present. Age prayed for Kama. List this matter after 2 weeks.
Yes, ma'am.
Okay.
The first week of December or 9th or 10th of December, ma'am, if possible, ma'am.
9 and 10 of December. You want fixed date?
Yes, ma'am.
Okay. And as requested, Kama, list this matter on 9 December.
Yes.
Okay.
There's an interim order, my lord. that may be-
Stop there. The interim order pass earlier shall continue till then. Okay.
Oblat.
Item number 12.
Wait, Pedro.
Yes.
IA is for implement.
Implement of a new party or
Yes, of the applicant, my lord. In fact, my lord, there were different sets of, I'm a field publicity officer. There were assistant director and deputy director rules in the department earlier. In terms of, there was a very peculiar rules. So we put it to challenge, my lord. I put it to challenge along with 3 other writ petitioners. Now, in the meantime, the private respondent junior was promoted to the post of assistant director on officiating basis. Now, during the pendency of the earlier writ petition, my lord, the rules have now been changed. Now the petitioner has filed this writ petition saying that he should be promoted in terms of the earlier rules because the vacancy arose when the earlier rules was in place. Now, in terms of the new rules, my lord, I am the person who is going to be considered. So I'm an interested party, so I may be implemented, my lord.
no objection? Okay.
My lord, I don't have any objection that way. In the meantime, the respondent 2 and 3, who is the main department, they have filed their affidavit. I may also be given some time to file my reply affidavit. And my lord, since it is question of promotion, whether it is me or the would be private respondents, but there is no point keeping it pending for long. So I may be given some time to file my reply and then setting up time for the private respondents to file their affidavit and with reply.
My lord will allow the IA, my lord, I will file the
Yes.
affidavit.
Okay.
My lord, in that case, may I submit that all this filing of affidavit reply should be completed within the month of November, and we can fix the date for final disposal of this case in the middle part of December.
My lord, I
Okay.
pass order in the IA first.
Yeah, let us heard Mr. D. Pangan, Land Council for the applicant. This is an application for implement of the applicant as respondent number 6 in the writ petition C 216 AP 2025. It is submitted that under the new rule,
New rule.
the petition and the applicant
Applicant.
is
Yes.
entitled for promotion to the post of
To be considered for promotion. my lord.
consider for promotion to the post of
Assistant Director,
assistant director.
Director of Small Savings.
And since the petition in the writ petition number 216 has challenged, he has challenged
He has filed this petition with a prayer that
the
he should
petition
be
with the prayer
promoted in terms of the old rules.
that he should be promoted in terms of the old rule. Stop. The in the earlier sentence, and therefore he is a necessary party. Stop. Okay. After then then the Land Council for the opposite party, which petitioner Mr. T. Partin has no objection. In view of the above, this IA is allowed. The petitioner, the applicant, Mr. What is his name? Milaram Modi.
No, Jothoyun. Applicant is Jothoyun. Milaram Modi is the petitioner.
Okay.
Writ petitioner.
Jothoyun.
Okay, Jothoyun. Now, in view of the above, let the applicant Sri Jothoyun be implemented as respondent number 6 in the writ petition number 216 AP 2025. With the above, this IA stands disposal. Okay. Then in main,
My lord, the cost title will have to be corrected.
in the main it will be corrected. In view of in the main, in view of the order passed today in IA 188 AP 2025, Sri Jothoyun is implemented. Jothoyun is implemented as respondent number 6. Stop. The petitioner shall amend the course title by inserting the name of the newly implemented Ms. Sri Jothoyun as respondent number 6 in the course title. Okay. Stop. Para. What is your prayer? You said
My lord, 3 weeks to file the affidavit of
Okay.
opposition.
affidavit in opposition.
Of respondent 2 and 3.
You want to file reply?
Yes.
Okay. This year, then, since the notice will be issued to you then,
No, my lord, I am already here, my lord.
okay, since Mr. Pangin is present on behalf of the newly implemented respondent number 6, no formal notice need be issued. Stop. However, he prays for 3 weeks time to file affidavit in opposition. Stop. Mr. T. Partin, there are Land Council to the petitioner also seeks 3 weeks time to file affidavit in reply to the affidavit filed by the respondent number 2 and 3.
2 and 3.
Okay. Stop. The prayer is allowed. I think this matter after
3 and 4, 4 and 5 Nepal. They are not
2 and 3.
2 and 3 only.
Yes. Yes.
This matter after
3 weeks.
after 3 weeks.
After
After 3 weeks. Okay.
Obliged.
Item number 14.
May I please, Lordship?
Yeah.
Lordship, the petitioner before your Lordship is praying for a direction to the respondent authority to release him from the government secondary school Nyafin.
Yes, yes.
Lordship,
So what was the reply from the of the government?
My lord,
You were not released. You are not released because some other
no reliever, Lordship.
no reliever.
Yes, Lordship.
Reliever is to be posted. Whether reliever now posted,
No, Lordship.
you were to file counter affidavit.
my lord, counter affidavit we have not yet filed, my lord. My lord, anyway, my lord, this matter can be disposed of, my lord.
Okay, with the
My lord, this can be allowed, my lord.
Okay.
Yes, Lordship.
My lord, the only problem why he has not been yet released, but is that the concerned authority principal, they have to apprise the authority the requirement of the guest faculty, my lord.
Hmm.
That has not been done because of the communication gap, my lord. He has not been released, my lord.
Hmm.
And in that aspect, my lord, the writ petition can be, my lord, this can be disposed of, directing the authority to release, my lord. In the meantime, whatever the guest faculty requirement, they have to apprise to the authority.
Okay. Heard Mr. K. Lowland, Land Council for the petitioner. I've also heard Mr. Tugong, Land Standing Council for the Education Department. There. By filing this writ petition under Article 226 of the Constitution of India, the petitioner seeks a direction to the respondent authorities, more particularly which one?
DDS, Lordship.
More particularly, DDS is respondent number?
Respondent number, Lordship. For 3, Lordship.
Respondent number
3.
My lord, it is the case of PGT. PGT, my lord, the principal can.
The
Principal
respondent
is respondent number
4, Lordship.
4. To post a, who will post guest faculty?
My guest faculty, they have to, principal has to apprise the requirement of authority.
Direction to a respondent authority will say, to post a guest faculty for, it's a, what subject? Mathematics?
Mathematics, Lordship. I'm praying for my release, Lordship. The posting of guest faculty up to the authority, Lordship.
Yes.
Well, he's been done. Madam, in his place, madam, the authority may apprise the concerned the school authority principal may apprise the authority for requirement of the guest faculty, madam. So far, I have
Okay. Direction to
release
the petitioner. From the, what school you said?
Government Higher Secondary School, Nyapin.
From Government High Secondary School?
Nyapin.
Nyapin.
Yes, Lordship.
In terms of the transfer and
Yes.
posting order number?
13/8/2024.
Okay.
Annexer.
Order dated 13/8/2024.
Yes, Lordship.
Stop. Para. The case of the petitioner is that by an order dated by the posting order number DSC 11012/1/2024 dated 13/8/2024, he has been transferred from Government High Secondary School, Nyapin, Kurungkume, to Government Higher Secondary School, Namsai, under Namsai district, with the condition that the DDSC stroke principal shall release the transferred teacher from the school as and when the guest faculty of the same subject joins the institution. Stop. Huh? It is submitted that although since then,
It's been 13 months, Lordship,
okay,
till today,
that
Lordship.
although 13 months have passed since
Yes.
then, the petitioner has not yet been released from the government school, government
Higher
secondary school, Nyapin, due to non-posting of the guest faculty stroke reliever
Yes.
at Government Higher Secondary School, Nyapin, Kurungkume, staff. The further submits that due to non-posting of the reliever, he cannot be kept stranded for such a long period.
Yes.
Staff, para. Mr. Tugom, Land Standing Council for the Education Department. Surely submits that due to some communication gap, he could not obtain necessary instruction to file affidavit in opposition. So, however, considering that this is regarding, you will deal with it within the department.
My lord, I talked to the authority, my lord. They're saying that the school authority principal, they should have apprised the authority requirement of the guest faculty in the institute, my lord. Since that has not been done, that's why, my lord, yes, a communication.
So, he fairly submits that in the instant case, the school principal
Yes.
has to, he has received
has to apprise the requirement of guest
the
faculty.
principal of the principal
Yes, ma'am.
of the school is to apprise the
Requirement of the guest
requirement
faculty in
of
the
the
institute.
guest faculty to whom?
To the authority, ma'am, to the director secondary
To
education.
the authority. That is respondent number 3.
My lord, 2, my lord.
Two. However, the same having not been done. Is it so?
My lord, that's why, my lord, guest faculty could not be.
The
my lord.
guest faculty could not be posted in at Government Higher Secondary School, Nyapin.
Yes.
However, due to the failure on the part of the authority, the petitioner cannot be kept continuously for such a long period. Therefore, he has no objection if the present petition is allowed for release of the petition, for his release. Okay. In view of the above, and considering that the petitioner has already been transferred and not yet been released for over 13 months. This court is of the opinion that the petitioner deserves to be released from the said school. Accordingly, the petition is allowed. The respondent, the authority, more particular, the respondent number 4 is directed to release the petition from the Government Higher Secondary School, Nyapin, Kurungkume, to enable him to join the new place of posting at Namsai. At Government Higher Secondary School, Namsai, within 15 days from today, from the date of the receipt of this. So, the date of receipt of the certificate copy of this order. So, with the above this Writ petition stands allowed and disposed of. Okay.
Deeply obliged.
Item number 15.
Please, Lordship. Your Lordship yesterday wanted to know about whether the vials should be segregated from the substance or not.
Okay.
This was the question
Yeah.
put by Lordship. In this case, I have searched the judgments of our apex court. There's a landmark judgment with Hira Singh and another versus Union of India and another. That's the only judgment which I could find.
Okay. Rest is against you.
Yes, it is, though it doesn't say that vials should be segregated, but what?
But the neutral substance
yes,
cannot be segregated, Lordship. However, Lordship, we received CD and I had already solicited the accused, Lordship.
Okay. Then
So, Lordship, the trial court is in a better position, Lordship.
Trial court has already rejected the application on merit. That's why we have come before this honorable court. Yes.
the offense is under 21B.
Yes. Here, regarding that, Lordship, the substance has been mentioned at para.
See, now what we'll do, in view of the order, if there is an order for segregation, then since the trial court has segregated, I have no idea.
No.
We can direct the trial court to consider your case in view of the Supreme Court judgment. To segregate.
Here, we have approached with that argument before the trial court, that has been rejected. That's why we are here before this honorable court. Now, on the same ground,
Which para you said?
the Lordship may kindly come in the judgment.
Yes.
Judgment is para 10, it starts.
Para 10.
Yes, last second page. What happened in the case of E. Michael Raj, the Honorable Supreme Court earlier said the main substance and the additives which are mixed with the drugs should be segregated and only the pure amount has to be counted. That was the judgment in the earlier Supreme Court. That was sent before the larger bench and 3 bench judges have passed this order. Now, in this order, the Honorable Supreme Court says the substance which are made as an additives, what happens in the case of heroin or any kind of drugs, sometimes they mix with charcoal or other medicines and all that to enhance the drugs. So when those are seized by the police, then they should not be segregated and counted as whether it has been a large or a small quantity. In that case, Supreme Court says it need not be segregated. Additives or substance which are added with the drugs. So those also should be counted. This is the judgment. In that,
the decision of this court.
Yes, sir. In case of E. Michael Raj Supra, taking the view that in the mixture of narcotic drugs or psychotropic substance with one more neutral substance, the quantity of the neutral substance is not to be taken into consideration while determining the small quantity or commercial quantity of narcotic drug or psychotropic substance, and only the actual content by weight of the offending narcotic, which is relevant the purpose of determining whether it could be constituted small quantity or commercial quantity is not a good law. So that earlier judgment that it should be segregated has been put to rest, but it need not be segregated. Second, in case of seizure of mixture of narcotic drugs or psychotropic substance with one or more neutral substance, the quantity of neutral substance is not to be excluded and to be taken into consideration along with the actual content by weight of the offending drug while determining the small or commercial quantity of the narcotic drugs or psychotropic substance. This is the ultimate Supreme Court laid that if those are mixtures to add or enhance the drugs, that has to be counted.
Not a good law.
Now, in this case, my lord, in our case, what we are saying, my lord, we are not saying that the additives or substance which are mixed with the drugs should not be segregated. What we are submitting before this honorable court is that the vials, my lord, a vial is a my lord, glass substance. It is not a thing that is mixed to be mixed as a substance to the main drug. Those substances should be segregated. Plastic should be segregated. Plastic is not an item which can be mixed with the drugs and enhance its power or enhance its quantity. That is not there.
Person that is dealing with the drugs and we are counting that plastic to be segregated and then he is saved.
Yes.
It'll be little difficult for me.
Yes, Lordship. It is the subject matter of Lordship, trial Lordship.
Your Lordship has clearly
segregation, Lordship.
clearly seen the seizure, my lord. Seizure has clearly indicated that it's the weight is counted with the vials. It has not been, but in the other cases, my lord, the police in the same matter has segregated and counted the substance differently.
How long he has been inside?
99 days, my lord.
Now 99 days.
Yes.
Charges when filed?
On 31, Lordship. After moving of this bail application.
My lord,
on 31, Lordship. Yes.
Hmm?
On 30,
I have
3110, Lordship.
I have
3110 is on which date? That means after expiry of how many days? After how many
90 days.
of arrest?
90 days of arrest.
Okay, within 90 days, charges filed.
Yes, Lordship. It appears.
My lord, in this case, what we are submitting, if the vials were not counted, the thing would have been intermediate quantity and we ought to have been released within 60 days. That's our case in this matter.
That measurement have to be taken at the time of,
Yes, during-
is to be argued at the time of the evidence only.
No, my
At
lord,
the moment,
Lordship will here.
he's under
Can you see the
21B.
21B, Lordship.
Yes.
He was
Now you want
book under 21B, but Lordship, the trial court rejecting that they have in commercial quantity. They are in possession of commercial quantity, Lordship. That's why his bill was rejected, Lordship. Next.
otherwise, the case was registered against him under 21B.
Yes, Lordship.
And 21B.
Is intermediate.
That is taken then is 60 days.
Yes, 60 days.
And the trial court calculated that it was
Commercial matters. That's why.
commercial.
Yes.
Yes, Lordship.
That would attract 90 days.
Yeah.
No,
180.
180 days.
Manifestly, it's wrong. Lordship will see the orders passed by the learned special judge, my lord. In other cases, the police segregated the vials. In a case of other accused persons. In case of this person, accused person only, it was not segregated and the vials were also weighed with the substance. In other, 2 accused persons have been released. In their case, the vials were separated from the substance and weighed and found small quantity. Orders there, Lordship.
It'll take time.
Regarding that, whether this should be separated or not, there's a very, Delhi High Court, there's a very beautiful judgment regarding quoting of the Hiralal case and all that, I'll just.
Mohammed Nasir.
Mohammed Nasir. But here, para 23, my lord, arrest. What happened, in this case, the Delhi police seized the contrabands that's allegedly be mixed with the bedsheet, towels, and all that. It came to more than 1 kg, man. Therefore, it was treated as commercial quantity and they were put into jail. And this bail application was moved before Honorable Delhi High Court. Now, para 23, my lord. The quantity of contraband also assumes its relevance as quantum of sentence to be awarded for an offense of possession or transporting a contraband committed under Act is also dependent on the fact that whether the quantity of such contraband is small, commercial quantity or intermediate quantity. Therefore, it was necessary for the respondent NCB to determine the quantity of contraband which has been recovered before an obligation is cast upon the petitioner to fulfill the twin condition under Section 37 of NDPS Act, which to satisfy court that there are reasonable grounds for believing that he is not guilty of such an offense, that he is not likely to commit any such offense while on bail. The case of respondent is regard weight of contraband recovery is borne out from the complaint, relevant extra which are reads as follows. Madam.
Okay. Anyway, so just Mr. Tapo,
Yes.
this is last date for me, and I have hardly time, and this needs a little discussion.
Definitely.
Even if you write judgment also, because you have to justify it.
Yes.
The line trial court has observed, and then they have taken into and then not segregated, and that has to be justified.
Yes.
It will take time, and then I have hardly time.
Then it can be listed on Monday or Tuesday.
Monday, Tuesday will
Yes.
get listed. Otherwise, thereafter, I'm coming. If it remains pending.
Yes, yes, madam. It is a bail matter, so
I'll be
definitely,
able-
yes.
Okay. And probably because case was registered against him for intermediary.
Yes, Lordship.
Then it is not the right stage, probably for the trial court to calculate that, because it has to be on during evidence only. It has to be.
Yes.
All those things, Malad, has to be.
That is subject matter of
That is
trial.
to look into, and then
Now, Malad,
need some discussion.
no parity was also
Parity
carried.
also.
Yes, because in case of others, it was segregated. Only in my case, they were
So
it was
because
not segregated.
in one case, I've seen that segregated and bail granted.
Yes.
And then here not segregated. So that little difficult. So that is to be discussed.
Yes.
Okay. Prayed for by both the Land Council for the party. Let this matter releases again on Tuesday.
Tuesday, madam.
Tuesday.
Yes.
Okay.
Deeply obliged.
Obliged, madam.
Item number 17.
My lordship.
You have not taken fresh steps. You who is for the petitioner?
Yes, sir.
You take fresh steps, not yet taken.
Not yet.
Okay, Mr.
Jet Manna.
Land Council for the petitioner. Prays for further 2 weeks' time to take fresh steps upon. No, just a minute, huh? Okay, fresh steps upon. Respondent number 3, 4, 10, and 11. The prayer is allowed. The petitioner is granted a week time to take fresh steps upon the above respondents by a registered post with AD as well as by usual process. Stop list is matter after 4 weeks. Okay.
Much obliged.
You are for respondent.
Yes, lordship. And for respondent number 5, 6, 7, 8, 9,
Okay, Mr.
12.
Mr. Bam.
Mr. Jibam, lordship.
G. Bam, Land Council appear on behalf, Land Council for the respondent number
5,
5,
7,
7,
5, 6, 7,
5, 6, 7,
8, 9,
8, 9,
12,
12,
13,
13,
14,
14,
15, 16,
15,
17,
17,
and 18, lordship.
and 18.
Yes, lordship.
Okay, it's also present, huh?
Private respondent. Much.
Item number 20.
Yes.
Lordship, this is a criminal appeal. In the last occasion, we were given some time to take.
Yes, you have not taken.
So we take further time to take some.
Okay, Mr.
Hey, government.
Land Council for the petitioner. Submitted inadvertently he could not take steps upon the respondent Therefore, pray for further 1 week time to take steps upon the respondent. The prayer is allowed. Steps. Oh, dusty service.
Yes.
Okay. Just leave that. Huh? Then Mr. So-and-so prays for further 1 week, 2 weeks time to take steps upon the respondent by way of dusty service. Which respondent?
No, I'm for the appellant.
Now, which respondent is to be?
Both the
You are to
respondent.
take steps for.
There are two analogous methods, 20 and 23. Both the respondent in both the cases are same. There's only sole respondent also.
Sole respondent.
Respondent.
Oh, to the respondent only, huh? The prayer is allowed. But it will be 2 weeks, huh? Mr. So-and-so is granted further 2 weeks time to take steps upon, for service of notice upon the respondent by way of dusty mode to be routed through registry of this court within 2 weeks from today. Start. List is matter after 4 weeks. Okay.
Lordship, item 22 is analogous to 20.
Okay. 20.
Yes.
20 and 22.
Yes.
Okay. 22 also similar order. What about this 21?
No, it's.
You are not in 21.
No.
Okay.
Item number 21.
Lordship, in respect of item, respondent number 6, I have to
Yes,
take the record.
still awaited.
Still awaited.
Okay. Mr.
Last occasion, record was also called for, I think like
Record, there is no office note. Record not yet received. Have you received the record? No. Okay. Mr. Koyu, Koyulani Council for the petitioner. And Mr.
Arsona,
Arsona for respondent number
125.
125. You are Mr.
I'm Gautam Natu.
Okay. Gautam
Natu.
Natu for Mr. Arsona, Lana Council for the respondent number 125 are present. So the office note dated 6/11/2026 reflect that the service report, service upon the respondent number 6 is still awaited. In view of the above, let this matter be listed after 3 weeks. Okay.
interim may be continued.
The interim order passed earlier shall continue till the next date of listing. Okay.
Item number 23.
Yes. You are for
Lordship, I'm for union.
respondent.
Respondent number, Lordship,
Okay. For no, who is for the petitioner? No one appears. None appears on behalf of the petitioner. However, Miss Gao,
yes, Lordship, Waigaon,
why Gao?
1, 2, 3, 6.
Land Council appear on behalf of Mr. M. Kato,
M.
Land DYSGI for the respondent number 1, 2, 3, and 6.
Yes, Lordship.
Staff, huh? So are you filing affidavit?
Lordship, we have already filed
You
affidavit.
have already filed. And this other respondent has not. in absence of the petitioner, the matter stand adjourned. List is matter after 3 weeks. Okay.
Item number 24.
It should be one. This is criminal petition.
Yes, Lordship.
Okay. Since the, your Miss
R. Chongrojo.
R.
R. Chongrojo.
R.
R. Chongrojo on behalf of the Johnny.
Okay.
Leading counsel.
R.
Chongrojo.
Jonglujo.
Chongrojo, yeah.
Jonglujo.
Chongrojo, CHON.
CH.
Yes, Your Honor.
Okay, Jonglujo. Jonglujo, learned counsel for the petitioner is present. Mr. Loy, learned PP is also present. The trial court record has been received. So, since the parties are duly represented and the trial court record has also been received, let the matter be listed for admission hearing. Admission, okay? After 3 weeks.
Idea of life.
Respondent number 3, Your Lordship. So, in main case, we inadvertently missed out the respondent number 3 too.
You are for the applicant in the IA.
Yes, Your Lordship.
Okay. You want that you should be included.
Yes, Your Lordship. Respondent number 3.
Why you should be included?
Because they are the owner of the disputed land, actually, Your Lordship.
Owner of the disputed land. Who is for the petitioner?
Me, Your Lordship.
Oh, petitioner has filed this writ petition.
IA, Your Lordship.
IA also filed by you.
Yes, Your Lordship.
IA is for
implement of necessary party, that is respondent number 3, Your Lordship. In IA, it is respondent number 3, Your Lordship.
So in the main writ petition, how many respondents are there?
Only 2, Your Lordship.
Okay, who is this 3?
First is Deputy Commissioner, Shiyomi District. Second is District Land and Revenue and Settlement Officer.
What is your challenge in the writ petition?
Your Lordship, we are challenging the order of Deputy Commissioner, Your Lordship. Order dated Order dated 08/07/2025, Your Lordship.
What by that order? What was the direction? What was passed?
In the actually, Your Lordship, in that direction, actually compensation which was to be disbursed between the parties. That was only half of the compensation for.
Okay, so you. By this writ petition, what was your prayer?
Your Lordship, our prayer is cause the set aside the impugned partial compensation order dated 08/07/2025 passed by the respondent number 1, Your Lordship, because this order is arbitral and illegal and discriminatory, Your Lordship.
So this is, you are the president of the clan.
Yes, Lord. Yes, Your Lordship.
Okay. Mr.
P. Wangpan, Your Lordship.
Land Council for the applicant. By filing this and also Ms. Sangeeta, by filing this in IA application, the applicant seek implement of Shri Mere European, comma, implement of Hedu clan.
Yes, Your Lordship.
Represented by Shri Mere European, President of Hedu Clan Welfare Society, as respondent number 3 in the writ petition number 428/2028. Staff. Para. Where is the order whereby whereby it says that the Hedu clan is also owner?
Your Lordship, it can be seen in the annexure 4.
Yes, yes.
In annexure 4
It's
of the
annexure
petition.
6.
Yes.
Not 4, annexure 6. 6 or 4?
There is a there is a notice issued by the Deputy Commissioner.
Okay, annexure 4.
Yes, Your Lordship. Shri Mary European, President, Head of our Welfare Society.
Okay.
And number 2 is Shri Gopal Hemi.
Okay.
Also in 6 also, Your Lordship.
Just a minute. The petitioner file with petition number 428 AP 2025. What is your claim in the writ petition?
Your Lordship, that compensation must be disbursed in total, Your Lordship.
For
not in partial.
disbursement of the compensation of what land? Of the disbursement of the compensation in respect of land stretching from Pumbum Yorlong to
Parley
Taking
area, Your
Lingtak.
Lordship. Between Taking Lingtak to Pumbum Yorlong, which comes under the whole area of Pumbum Yorlong to Bos Sokong, Your Lordship.
Belonging to Hemi and
Mm.
Hedu Society. And since the Hedu claim, since the Hedu clan disputes the land claiming okay, should have been divided.
Yes, Your Lordship.
Okay, see, he's a lesser party for division of the compensation.
Yes, Your Lordship.
Okay. And therefore, the Hedu clan is a necessary party in the writ petition number writ petition C number 428 2025. Start. Hence pray for their implement as respondent number 3. Stop. The prayer not being objected to by the respondent, say respondent, is allowed. Stop. Accordingly, the allowed the let the Hedu clan represented by Sri Mere European, President of Hedu Clan Welfare Society, be implemented as mentioned in the application, be implemented as respondent number 3 in the writ petition. With the above, this IS stands disposed of. Then in the main, Mr.
P. Wangpan, Your Lordship.
Yes, land counsel for the petitioner. Also had Miss Sangeeta for the state respondent number 1 and 2.
1 and 2.
Stop. In view of the order passed today in IA number 268 AP 2025, IA civil, the Sri Mere European, President of Hedu Clan Welfare Society, Karle Village, POPS, Monigaon District, Siyomi, Arunachal Pradesh, is implemented as respondent number 3. Stop. The petitioner shall issue notice, the petitioner shall take steps upon the newly implemented respondent number 3 by a registered post with AD as well as by usual process within a week from today. Stop. List this matter after 3 weeks, 4 weeks.
3 weeks, Lordship.
After 3 weeks. Okay. IA dispose of to the above this IS can dispose of.
Item number 27.
Yes.
Lordship, in terms of order dated 2/9/2025, I've taken the steps upon respondent number 8.
Okay. How many respondents are there?
Lordship, there are 8 respondents out of 10.
8.
Yeah, altogether 8 respondents.
Okay. What about the other respondent? 8, it appears that notice served.
And for respondent number 1 to 7, they've already accepted the notice.
They appeared.
Yes, already appeared.
Already appeared.
By order dated 2/9/2025.
Okay. Then what next? To be fixed for admission?
No, Your Lordship, I have to take instructions, Your Lordship.
Okay.
Lordship, I have a small prayer, Lordship. Actually, my interim prayer was supposed to be considered today, Lordship.
What was the interim prayer?
Interim here in the petition, Lordship, the respondent authority, they are not.
What is this case about? Otherwise,
This is a case of compensation, land compensation, Lordship. Lordship, my land has been acquired for construction of hydroelectric project there at Tato under Siyomi district. However, I am not being paid adequately in terms of Lara Act, Lordship. That's the reason the petitioners are here before your Lordship.
Your Lordship, their main grievances is to display the final award. And that we have done, Your Lordship. We have furnished the documents also which they have asked for, Your Lordship, but they are not ready to take it, Your Lordship.
they furnish what?
Documents that they are seeking, Your Lordship.
Okay.
We have forwarded the documents, Your Lordship.
You file affidavit?
Your Lordship, detailed affidavit, Your Lordship.
How long it will take?
3 weeks, Your Lordship. 4 weeks, Your Lordship.
Okay, hard, Mr.
Lordship, the document which the Learned Council is relying, that document I have received. However, Lordship, on
Have you annexed? Yes.
yes, I have already filed my additional affidavit on with that regard, Lordship.
Okay.
They have.
You have filed additional affidavit?
Yes, Lordship.
They have not yet filed affidavit.
No, I have filed additional affidavit on that aspect, Lordship.
Additional affidavit they have filed on 2nd, Your Lordship. We have forwarded the document on 8th September, Your Lordship.
Okay.
8th September.
Okay. Mr. Lanika, Government Advocate. For respondent number? 1 to?
1 to 7.
1 to 7. You have received, that means you have already received instruction.
Instruction I have not, instruction I have received what documents, but not
Okay.
proper para-wise reply I have not received.
Okay. Although she has received some instruction along with documents, however, however, the parawise comment is still awaited.
Yes, yes.
And prays for further.
4 weeks, Your Lordship. It's from Siyomi district. It's very difficult to.
Which district?
Siyomi.
4 weeks time, huh? Stop. Huh? The notice upon the respondent number 8. The notice upon the respondent number 8 return. Return with a comment. It was received. Just a minute. Huh? Where is the notice served?
Yes, Lordship, I have already served taken steps upon respondent number 8 on 5th September 2020.
Just a minute. Huh? Okay, duly served. Huh? However, no one appears on behalf of the respondent number 8. Stop. Huh? In view of the above, in age prayed for by the learned government advocate, let this matter be listed after 4 weeks.
4 weeks, Lordship.
Lordship, observation made in this order dated 2/9/2025 in last sentence, Lordship, may be continued.
Last one, in the meantime, till the returnable that the collector, deputy commissioners will ensure compliance of the mandate of.
Section 38.
Okay. In the meantime, the observation made by this court on 2/8/2025 that till the collector, that till the returnable, that the collector.
2-9, Lordship. It's 9.
2-9.
2-9, yes.
What did I say?
2-8.
It's 2-9.
2-8, said.
It's 2-9.
Yes, 2-9, Lordship.
The first one was 5-8. Okay. Collector, Deputy Commissioner, CEOME will ensure compliance of the mandate of Section 38 of the LARR Act 2023 shall remain. Okay. Shall continue. Okay, till the next date. Okay. Stop. List is matter after 4 weeks. Okay.
After your lordship.
Complete. Okay.